Joining us today is Sarah Fox, who's a consultant to the AFL-CIO on various legal and policy matters. Ms. Fox is of counsel to Bredoff and Kaiser law firm. She previously served on the National Labor Relations Board and was Chief Democratic Labor Counsel to the U.S. Senate Committee on Labor and Human Resources. Prior to that, Ms. Fox was in-house counsel to the International Union of Bricklayers and Allied Crafts. She holds degrees from Yale University and Harvard Law School. Welcome.
Of counsel to the Washington, D.C. labor law firm of Bredoff and Kaiser, and I'm also a former member of the National Labor Relations Board, having served on the board by appointment of President Clinton from 1996 through 2000. I appreciate the opportunity to testify today, and at the outset, I would just personally like to commend the committee for undertaking consideration of not only this matter, but also H.R. 800, the Employee Free Choice Act. The National Labor Relations Act was enacted in 1935, but unlike virtually every other major New Deal statute, it really has not been periodically revisited and updated by Congress. Despite significant changes in the structure and organization of work that have really transformed labor relations in many industries, and significant problems that have developed over time in the administration of the Act and particular provisions of the Act, because of a kind of impasse, a political impasse at the federal level between those who would want to reform and those who are against, there really has not been an opportunity to really take a look at what is at this point a 70-year-old statute. And I really do think it's very important that this subcommittee, that Chairman Andrews and others are, through these legislation, these two different bills, really taking a look at this question and giving us an opportunity to really have a debate about the kind of labor law relations system we really want for the 21st century. So just with that background. I also want to thank you for taking up this particular issue because of my own experience as a member of the board. During the 5 years that I was on the board, I would say that the issue of whether particular employees were or were not supervisors was probably the most litigated issue before the board. I think I would estimate that about 1/4 of the cases we decided in those 5 years involved in one way or another questions about whether employees were supervisors. Over that time, I really came to believe, and I will argue today, that there is a fundamental problem with the statute and a fundamental tension between the strict literal words of the statute and the intention of Congress when it enacted this particular provision in 1947 not to exclude professionals and other skilled employees who, as a matter of course, direct the work of other employees. So I do think that this is a wonderful opportunity to deal with something that has been festering for a long time. Let me say that first, why it matters. For purposes of the NLRA, whether a worker is classified as an employee or a supervisor can be an incredibly important matter, not just for that worker, but for co-workers as well. Obviously, as Chairman Andrews said, someone who is classified as a supervisor has themselves no right to engage in collective bargaining, can't have a union, can't bargain over their conditions of work. But being a supervisor means not only that you have no affirmative rights under the Act, but also that you have no protections under the Act. Because supervisors are not covered by the Act, a supervisor can be disciplined or fired for engaging in pro-union activity, and a supervisor can be required by their employer to actively participate in the employer's own anti-union activities. A finding that a particular individual is a supervisor and not an employee can also have a devastating effect on the organizational rights of the other employees in the workplace. That's because under a 2004 decision by the NLRB in a case called Harborside Healthcare, the participation by a supervisor in pro-union activities can be grounds for setting aside a vote by the employees in support of unionization, even though that supervisor did not at the time time he engaged in that activity, he or she engaged in the activity, know that they were a supervisor, did not consider themselves to be a supervisor. But because of this doctrine of what is called supervisory taint, we've had, for instance, a decision in a case called SNE Enterprises last year in which the board refused to accept the results of an election in which the employees voted in favor of the union because two lead persons whose sole authority over the other employees consisted of the ability to assign workers to different production line tasks had participated in soliciting authorization cards used only to support the filing of a petition for an election. The board held that the leads' actions on behalf of the union were inherently coercive, even though the leads had participated, had voted as employees in 3 previous NLRB elections. And once their employer informed them that at this point the employer considered them to be supervisors, they had stopped all pro-union activity 3 months before the election. Nonetheless,
you could wrap up for us, please.
Yes. So I just want to say that it is very important that the committee address this issue today, and I look forward to some discussion with the others about it.